welcome to Nuts and Bolts of Entertainment Contracts. I'm Ala Poli Castro, CLE Advisor with the Beverly Hills Bar Association. Today, I'm happy to introduce the speakers of today's program, Neville Johnson and John Baldivia. Mr. Johnson is a distinguished entertainment and intellectual property attorney with over 4 decades of experience, having tried more than 28 jury trials, 70 non-jury trials, and many arbitrations. A member of ABOTA and a recognized super lawyer since 2006, he has been named one of Southern California's top 100 lawyers and honored as Hollywood Reporter's legal legend. Mr. Johnson has represented prominent celebrities and entertainment entities, specializing in net profit disputes, copyright infringement, privacy rights, and class action against major industry players. He is also an accomplished lecturer, writer, and adjunct professor, recognized for his precedent-setting case, Sanders versus ABC, which established workplace privacy rights. John Baldivia is partner at Rossi PC, specializing in negotiating contracts for major label artists, songwriters, and influencers with expertise in music transactions and entertainment litigation. Previously, he was a partner at Pierce Law Group, where he handled music and film contracts, copyright clearance, and complex litigation, securing 6- and 7-figure judgments for his clients. Recognized as a super lawyer rising star in 2020 and 2021, John also spent a decade working in the music industry with major and independent record labels. We can't wait to hear what they have to share with us today. And now over to you.
Well, thank you and good morning, and we're very pleased to be here. We're going to be talking about stuff that you should all have on the tip of your tongue because they're commonplace issues that arise, and it's not just for entertainment, but generally in business and life itself overall, and things to think about. The first thing we're going to talk about is arbitration clauses. Every movie studio requires arbitration, as do most of the major record companies and many other entertainment entities. The question is whether that's a good thing or not. I've done a number of indie films that fall under the IFTA, International Film and Trade Association. The dispute might be over $150,000, and you might spend $40,000 on the arbitrator, on top of which legal fees are building up. It doesn't necessarily pay. And so I'm suggesting to all of you, whether you're on the business side or not, to be thinking seriously about whether you want to engage in arbitration. People like arbitration because it's non-precedential and because it's confidential. And I'm not saying all arbitration is bad. I'm just saying the expense can be prohibitive overall. I'll give you an example. AAA has a requirement that if you have a claim for $1 million, the filing fee is $7,700 and a later fee of $8,475. And then on top of that, you pay arbitrator hourly fees. So that may be prohibitive. There is authority that if a party cannot afford arbitration, the other side has to pay for it, or it can go into the court system overall. Now, by the way, I've given you an 8-page memo that details the law on most of the stuff that we're going to be talking about, and summarizes what we're doing. What jams, of course, everybody knows about. They're the grandfather, really, of the mediation dispute centers. Every single contract with the majors, the studios, requires jams, and there is some thought that it suffers from repeat player bias. In other words, any arbitrator will be fearful of levying a major verdict against the studio for fear he or she will not be hired again as an arbitrator or a mediator overall. And there's a law review article written by Ron Nessum that I give you a cite to that does an extensive analysis of this overall. One of the problems with arbitration is that you don't know the background of the arbitrator. So I want to know, how has this arbitrator ruled in the past? Even if I don't know the parties on, say, a net profits dispute, I'm not going to find out. Whereas in the Superior Court or the Federal Court, I can get a pretty good handle on where the judge is coming from. As I said before, I'm not against all arbitration. My fee agreements provide for arbitration. It used to be a blanket, I want arbitration in every agreement. And then I decided, well, wait a minute. If it's a small matter, if it's under small claims court jurisdiction, I'll go small claims. If it's under 35,000, that's limited. I'm happy with limited. If it's under 150,000, I'll go with the Superior Court overall. What's the advantage of that? Well, I don't want business on the street necessarily, and B, it can also cover malpractice disputes, assuming one of those arises. Couple more things to be aware of regarding to arbitration is that you might want to say if they're dogmatic that, and it's non-negotiable, and that's been my experience, and I have done enough of these, including with majors, including on behalf of prominent people, where they just say it's too bad, that's the way it's going to go. No way. And if you've got a client who's making $5 or $10 million, he or she doesn't care really, because it's not going to happen until years down the road, but it may happen. But document it and say, put something in the file. Maybe it'll be useful later on to say, you told me this was non-negotiable overall. Also, try and arrange, if you want to have arbitration, then how about we open it up to the field of whoever is out there, not just at jams? Or how about we also require that the arbitrator, whether it be a retired judge or an entertainment attorney, that he or she be knowledgeable about entertainment matters. Now, arguably the most important thing I'm going to tell you today about arbitration is the Axtron case, AIXTRON, which came down in 2020. And that says, if you do not have in your agreement for arbitration the right to obtain third-party discovery, you will not get it. That could be fatal to the prosecution or defense of any case overall. And so you might want to be thinking about any of the clients you've had in the past who have arbitration agreements, who before this law went or this decision came down, said that there's arbitration. You might want to say, you got to revisit this and provide for third-party discovery. I'll say one more thing about arbitration is that, and I've seen a number of these reality shows, which are extremely onerous and one-sided. And every single one of them says, you got to go to mediation first. I am a great believer in early mediation as much as possible. Most cases settle, as you know. A lot of times they can't be mediated or settled because enough information has not been obtained. But what's wrong with going to mediation and at least having a productive discussion about, well, what are the differences and what do we need to work out? I'm going to turn it over to John now. Say something.
I think my thoughts on the arbitration provision are really that oftentimes it becomes like a barrier for entry when it comes to dispute resolution, right? Especially when you're talking about smaller contracts. Let's say you're talking about an influencer deal where at most the fee was like $1,000, $2,000, right? And for whatever reason the influencer isn't paid or there's some kind of dispute with the agreement, already you're talking about a barrier of entry for the influencer to come in and enforce the agreement when there's an arbitration provision. And a lot of times when you're talking about, these influence agreements that have limited participation, limited fees, even because there's a big company on the other end of it, they're still going to require arbitration because they don't want these disputes to be public. And of course, the brand can afford it, but the influencer who's not making a ton of money on this deal might not be able to. And so, you see that often in influence agreements. Sometimes you see it in other contexts where there's an artist and a producer, where the artist doesn't want any disputes to go public, and so they have arbitration provisions. But again, when you're talking about a producer that's only making a couple $1,000s, now the producer's got to spend all that money and then some just to enforce a contract that they're not really expecting all that much money to begin with.
All right, good. So let's go over other things that you see in almost every contract. Choice of law. Why would anybody ever agree to the choice of law of another jurisdiction? You never want to be hometown. Do not agree to New York or Minnesota or whatever it may be. What's the advantage? There is none. California's got perfectly good laws, and you should not agree to them. If you have a dispute about it, what I say is, you know what, leave it blank, or we'll deal with it later. Or you can say sometimes, All right, if you want to bring the lawsuit, then you have to bring it in my jurisdiction or vice versa. Um, Venue. I don't, venue is the internal laws, the internal counties in California, and you would always want to be in LA County if you can, I would think. But you need to be aware of that, and that's something they could put in the contract. Forum selection.
Let me chime in there. Just so with respect to jurisdiction and venue, and oftentimes these will get coupled together in a contract, right? In the entertainment industry, there's obviously a strong preference for California and New York, and it largely has to do a lot with the way that copyright cases play out in either of those districts, right? You want to be in a district where you know how copyright laws are going to play out, or how the civil procedures laws are going to play out, whether in your favor or not. It's more or less just there's a further developed area of law, and so as the studio or as the record label, there's going to be a stronger preference for it. As many of you know, the music industry has become largely globalized. There are lots of people who are making music outside of California, New York, yet you're seeing these kind of jurisdiction choices of law apply within those contracts. And that just becomes another barrier of entry, especially when you've got independent creators who might not even be in the country, who then now have to bring a contract dispute in New York or California for something they may have recorded in Colombia or in Puerto Rico. Whether or not there's leverage to get those changes in there, that's just subject to negotiation. I think it comes up a lot in influencer agreements too, because the brand is always going to want to choose their home jurisdiction. And influencers are engaged all over the country, and all over the world, really. And so what happens when you've got a brand that's based out in England and they're trying to engage, trying to build their presence here in the US, they're engaging influencers here, and they've got a contract that says these are going to be governed by the laws of England, or laws of Wales, or laws of Ireland. It's one of those scenarios where you might not have the bargaining position to negotiate it out. So then what happens if there's a breach? You fight for it where you can, but a lot of times when you're talking about smaller contracts, maybe there's not a way around it.
Yeah, and I'm saying it's happening more and more. We had a dispute recently with the Dutch. They wanted Dutch law. Continuing on the subject of forum selection. Again, you want to be in your hometown, your home state. There's an important new decision that came down on November 14th, just 2 weeks ago, the Comedy Store versus Moss Adams. It's a published decision where the court said, we're not going to go with the state of Washington because the state of Washington does not view a jury trial as a fundamental right. So it's going to stay in California. So be thinking about if you're trying to get something waived, whether or not it's going to fly in another jurisdiction or the jurisdiction with whom your home is, or you're contracting with overall, for those of you who are representing people outside of the state of California. Next, we're going to talk about waiver of fraud or intentional conduct. You see this, I mentioned before, these reality show agreements in which they just say, we can say and do virtually anything we want. And is there a limit? And the answer is yes, there is a limit, but they habitually say, and I've had a number of people come to me over the years saying, I just was defamed. And I said, yeah, well, you just consented to it in this one-sided agreement overall. And maybe there's a way to get around it, but they're going to require you to go to arbitration, mediation first, sock you with all the attorney's fees, et cetera. It's a no-win game overall. But California Civil Code 1668 states that contracts that exempt someone from responsibility from their own fraud, willful injury, or violation of law are against public policy. So I don't care if you put it in there or not. a defendant is not going to be able to get away from gross negligence, recklessness, or an intentional act. But how about this recent case from 3 years ago, Smith versus American Idol, unpublished, where the court found assumption of the risk. Guy got a perforated eardrum based on the hearing devices they put in his ear, and they just said, well, that's ordinary negligence. That's too bad. You know, and it's a shame. Jury waiver. How about this? I have seen a number of contracts, I bet many of you out there have as well, saying, well, you are waiving a jury. Well, guess what? There's a California Supreme Court case, Grafton Partners, I give you the site, that says you can't do that. The right to a jury is a fundamental right, inviolate, sacred in its character. And so be mindful of that. Of course, you can say, you're going to go to arbitration. That takes you out of the game there as well. Speaking of arbitration, I will say one place where I do recommend it overall is that there's a Supreme Court case that says if you're a personal manager and you have an arbitration agreement and you want to evade or avoid the labor commissioner hearings, you can agree to go to arbitration because they're so pro-arbitration at the Supreme Court. We just finished an arbitration before the labor commissioner. Hey, folks, it took 2.5 years to get the decision. And that's not an isolated act. I know that from other practitioners in the field overall. So, and I would also say if you're on the personal manager side, you're generally going to do a lot better if you're in private arbitration as opposed to with the labor commissioner. Anything you want to say, John?
I'm going to piggyback off of that point about mentioning California law and the labor commissioner. So this goes back to the comment about choice of law. Is remember that when you're choosing California law, you are also agreeing to subject yourself to the laws of California's labor code, as well as, you know, if you're talking about in the music context, you're talking about California's statutory right to a royalty audit. You know, that sounds like it's a preference on perhaps the talent side, but on the business side, maybe it's not something you're looking forward to invoking involuntarily.
Okay, let's go on to another topic. Waiver of punitive damages. I'm sure many of our viewers have seen that in contracts. Well, how about this? There's a Court of Appeal decision, Lang versus Monster Energy Corp. 2020, that's published, that says a waiver of punitive damages as a remedy for all non-statutory claims is substantively unconscionable regardless of its mutuality. So you can put it in there if you want, but it's not necessarily going to fly overall. And if you think about it, when we talked about that previous clause that says you cannot waive willful, reckless, intentional conduct, it makes sense overall. When did we most recently see this played out? And the answer is Bones. The decision that was before an arbitrator who said, where there was a clause that said there will be no punitive damages, and the arbitrator was so incensed at the conduct of 20th Century Fox that he levied a very substantial award. I think it was about 28 million, and then over $100 million in punitive damages. When they tried to enforce it, the trial court said there's a waiver. I'm not going to enforce the punitive damage because it's a waiver, and then it's settled on appeal overall. So we don't know what's going to happen, but I know that the argument that was being made was that it was, you cannot have a law that is grossly inappropriate given intentional or fraudulent conduct.
Just a quick drafting point on that note. So on a lot of contracts, you're going to see this language, as I'm sure many of you know, and there's going to be situations where the talent buyer is refusing to remove this provision. But I mean, notwithstanding the California appellate precedent, another way to mitigate this is to limit it only in the instance where there's an absence of fraud or intentional misconduct. You know, you can talk about waivers of punitive damages, a waiver of equitable under injunctive relief, but only in the context that there wasn't any fraud involved in the breach. And oftentimes that becomes a way to move forward in a contract because one party's refusing to remove this language while the other side is refusing to just waive it completely.
You know, I was related to that issue is the topic of consequential damages. So many agreements say you're not going to get any more than what you were supposed to get paid in this contract or what money you're out overall. And from a business point perspective, that's what you got to do. If you're representing a company, you want to always limit your downside as much as possible. As far as I know, I haven't seen a case yet that said you cannot do that overall. All right, attorney's fees. You know, I would say my experience is that most entertainment contracts do not provide for the prevailing party to get attorney's fees and if there's litigation. And I'd say that I don't agree with that because I think my client's usually going to be in the right, or I hope so. And secondly, and most importantly, you can't get a lawyer to work on a contingency fee basis if the damages do not include the attorney's fees that the lawyer might have. We do a lot of right of publicity cases by analogy, and the Civil Code 3344 provides for attorney's fees. And a lot of times we'll take that case on because we know we'll be made whole at the end of the day, even if there's a fire going on outside my window, fire trucks. So for you who are representing anybody, think twice about why not have a fee shifting clause overall, because otherwise you may be out in the lurch and unable to prosecute your case or find somebody to defend it.
Well, I think that lies the rub, right? It's people omit the attorney's fees language because it makes it harder to litigate, right? I mean, let's be real. I think part of the tactic for it is to not leave an invitation for contingency attorneys to participate in a contract dispute. So
absolutely, if that's why the major studios and the big companies and everybody else, they don't want that. But you know, if you're making a middle management or middle of the road kind of a company or artist or anybody else, I think it makes sense. I just did a licensing deal for a small film this weekend, and the other side did not want to agree. And okay, we'll live with it overall. But I told him it's, you know, works to your benefit as well. Okay, now we're going to talk about audit rights. So you got to make sure you always have the right to audit if there's money involved somewhere down the line. My favorite audit clause I saw in a major motion picture you would all know said, you can audit if the film is in profits and the film is not in profits. It was like a blockbuster. So what do you do? And there is a right to audit recording agreements. That's California Civil Code 2501, but not for any other entertainment vehicle overall. And in that case the deal I just mentioned to you yesterday, that's why, thank God, my client sent it to me. It did not have a royalty provision at all, saying when or if they had to do it. So you got to, that's fundamental to any licensing deal overall. So if it's, make sure you have the right to audit and to audit as necessary. And oftentimes many agreements, I won't say most, provide if there's a 5% or 10% discrepancy, they will pay the cost of the auditor. Well, that makes sense overall. Anything you want to say on auditing, John?
more of a question, actually. The 2501, I believe would apply in any music royalty context, right? Not just recording contracts. Would publishing agreements be in?
I think it's just record companies, as I recollect.
Okay. Again, you know, when you're talking about choice of law, you know, if you've got California choice of law and you're representing talent, that's certainly a great benefit to have, a tool to have in your arsenal. If you're someone who's on the side where you're paying royalties, you know, it's something to be conscious about. And I don't know enough about the provision to know what the statute of limitations are for this. I think it might be 3 years to invoke a royalty audit under statute. But keep in mind that whenever you're dealing with music contracts, oftentimes you're talking about limiting the amount of time you have to review royalty statements. And it's primarily used to limit the time period shorter than the statute of limitations. And so when you're limiting that that period under the contract to review a statement, is that also affecting the time that you have to review royalties if you're seeking an audit under statute?
Yeah, we could do a whole program on auditing and the misery that forensic auditors are going through right now.
Yeah.
One of the things you want to make, you know, we'll discuss a little bit, is that they are not letting you go. The record companies are not letting the auditors take a serious look at the books. They're limiting them to maybe 2 years or so, whereas they may be holding money for 10 or 15 years. And that's something it would be nice to negotiate for, that you could be able to see these accounts overall.
I think you could even take it a step further. In the contracts, it'll have language that says you can only audit and review material in the royalty statements for things that you have identified in your notice letter. And if you don't write your notice letter properly, you may have given up your right to review certain documents.
I'll just say this: we're having such problems. Here's what's going on in auditing right now. In motion pictures, they say we'll see in 3 years or 4 years by the time they're going to let you, and then they take a year to go back and forth till you finally make your deal. Same thing with the record companies. They put you in a queue that may be well over a year before they're going to let you in the first place. And you know, somebody ought to do something about it. Okay.
Let me piggyback a little bit more on the audit rights point. So, of course, when you talk about audit rights, you're talking about royalty statements, right? And certain contracts will have language that says a royalty statement is going to be deemed delivered on the date that it's due. Now, that's something that I think a lot of us have experienced. You always want to look out for that. Make sure that the clock doesn't start running the date when it's due, especially when the royalty statement hasn't actually been delivered, because then you're already running the clock at that point. The other thing to be wary of is contracts that say that you can't file a dispute about a royalty statement until after you've conducted an audit. When you're talking about, you know, talent who was brought on and made minimal fees, but could be substantially owed a lot of money had the royalties been paid through, that becomes another barrier of entry, because, you know, here's somebody who's waiting on the royalties to come in that never came, and they now have to seek an audit, you know, pay $10,000, $25,000 to conduct the audit before they could even file suit. It's you know, I don't know how that plays out in the conscionability standard under, you know, contract review, but it certainly comes up in a lot of entertainment agreements, and something to be mindful of when you see it.
It costs like $50,000 or $100,000 to do a proper movie audit. And, you know, that's a lot of money to put out. We find more and more that we get such pushback on audits that we just say, we're going to file a lawsuit. We'll do discovery through the legal system. And it's much more efficient because they can't say no to a judge. All right, on a side note, I want to mention, we've seen this come up and probably ought to be talked about in contracts that you do. What happens when an income stream is sold? We used to have a law firm that was saying, I want 5% of that money. And ultimately the matter was resolved, but it's going to come up more and more. Does the manager get a piece? Does the agent get a piece? You ought to be thinking about that. Also, we had a case where we represented a producer of a superstar on a superstar album. Then the talent settled with the record company for a lot of money, and nothing went to the record producer, who we ended up filing an action for and ultimately settled it. But that's an example there of you should be thinking about, how do I cover that? not only if there's a resolution of somebody who's a partner with you and the other person gets a bonus, but also what happens when a catalog is sold. Let's talk
There's-
about special purpose.
To that-
Go
To
ahead.
that point about catalog sales, you'll see it often in reps and warranties on the person who's selling. Let's say, for example, an artist is selling to a fund who wants to buy catalog, right? The artist is making certain reps and warranties that, with respect to any royalties that are owed, that either the royalty recipient, aka the producer, is either paid out or is accounted for and has been disclosed. And so, from a transactional side, that's supposed to be contemplated, whether or not the buyer is going to take over those royalty payments, those royalty obligations or not. And an issue arises often because the producer absolutely has no visibility on the sale between the artist and the buyer. Is, well, now who does the producer go to for these royalties?
Good point. All right. Special purpose vehicles, seemingly every single television and movie production has what's called a special purpose vehicle, an LLC or a corporation that might be set up through which everything's going to be run. Before I go any further, somebody asked, do we, there's handouts. I gave an 8-page handout with this, which if you go to the chat room, I think you can get the link to it overall. But anyway, special purpose vehicles, what's going to happen if there's a breach? You're going to sue an empty shell effectively overall. So you all out there need to be aware of special purpose vehicles and standby or alternate additional liability in the event of some sort of a breach or, God forbid, some tort such as fraud that occurs or breach of fiduciary duty overall. Now, you can, of course, if there is fraud or another tort, you can name an executive or somebody who was in a position of power that could be held liable overall. But again, you'll probably run up to this in a special purpose vehicle situation, that clause I told you about before of no consequential damages overall, and which may make it totally unworthy. We've had this problem. Next one we're going to talk about is collection accounts. And I can't tell you how frustrated I have been in my experience with collection accounts, like Vintage and Freeway are two of the major ones overall. This is when, let's say an investor comes in and puts money in, and he's supposed, or she is supposed to get, or it is supposed to get money off of the profits and the revenue, and they want to see what's going on. Well, how about the situation I had recently of a guy who wrote the script and put 100 grand of his own money into it and is not on the collection account. So he has no idea what's going on with the finances, and they treat him in a totally haughty manner overall. What's my point? My point is that if you have talent or somebody who's going to be paid based on the revenues coming in, whether they're an investor or talent, you want to be on that account with full rights to see all the money coming in and the right to audit, just as anybody else would have such a right, because there's such screwiness going on in the indie film world overall that you just need to pay very, very close attention to it. Accountings. John talked about internal statutes of limitation. I think there's every single contract I think I've ever seen provides for an internal statute that is shorter than a statute of limitations, shorter than the code. Code is 4 years, 2 years on an oral contract, but 4 years, ordinarily you're going to see 2 years overall, and you have to object. And there is the very difficult case that came down in 2017 that was very harmful to royalty payees, namely Windancer Productions Group versus Walt Disney, in which they said, you need to object as soon as you get the statement. And if you don't, your statute of limitations is running and you're out of luck. The problem is the conundrum that most movies and TV shows don't earn out until 5 or 4 years later. And it doesn't pay to necessarily object or certainly to do an audit. the antidote at best is to object and get a tolling agreement if you can. Hopefully you have a good relationship with the payor overall. But you need to be very mindful of these, of this particular position. I'll mention also, it came down, I think, I'm not sure, the Bill Nye, the science guy versus Walt Disney. This is about a year ago, 6 months ago. That is a decision where they said, the argument was that streaming monies are not the same as home video, and we should be getting paid on 100% of the revenue. You know, what happened with home video was that 25, 30 years ago, they kind of concocted a methodology by which the talent got paid on 20% of the gross revenues. And then, so if you had a 5% of the income coming in, you got 5% or 20%. And of course, home video was driving the marketplace at that time. Well, now there's no more home video. There's no distribution, there's no blockbusters, and it's a different world entirely. There's no physical product. And so the argument was that I should get paid on streaming at the 100% rate. And 3 trial court judges said, no, Disney says this is our policy, and this is, we say it's home video. They put up some internal executives who said that's what we think, and Bill Nye's people came up with some other people, and the court went with Disney overall. So that's an example where they just interpreted their contract the way they wanted to interpret it in the face of new technology that came in. Speaking of which, you always want to be thinking about new technology, and I don't even know where to go right now when it comes to AI. It's so chaotic overall, but everybody's scratching their head and trying to figure it out right now, just like everybody's been scratching their head for the last 10, 15 years on how do you get paid in streaming. And what was the result? The result was that you don't get back end anymore. You're just going to get paid a big profit if you're lucky when the deal goes down. And now Netflix is pulling back and saying, well, we don't know if we like that model anymore. And you look at the Disney and other places, and they say, well, if you have awards, if you have a good opening in the movie theaters, good critics, other things like that, you will get bonuses, but you are not going to get back end. It looks like it's the death of back end. John?
With regards to accounting, I think it's always important to pay attention to who do you actually have the right to receive the accountings from and to conduct the audits from, right? If you're a producer, oftentimes your rights are against the artist, but the artist is often passing on the obligation of providing the accounting to the record labels. As a producer, you're often than not going to have the right to audit the record label directly, and so you're reliant upon the intermediary to maintain accurate books and records in order to provide an accounting in the first place. Now, you know, it becomes an even bigger issue when the artists themselves haven't received their royalties, and then you as a producer, you're kind of stuck, you know, second in line, where you can't even get the statements until the artist gets the statement first.
Yeah, you want to have the right to see any audits the artist does and to participate in the resolution of any such audits overall. Otherwise, you're just hanging out on a limb.
Right. A couple other points for accountings, which aren't necessarily related to audits, but there's this concept of windowing when it comes to accountings. Let's say that at the end of Q4 of 2024, the royalty account is in a payable position, right? January 1st, you take an advance or incur significant cost where you now receive, you know, a certain, you know, large sum of money from either the label or the production studio, where the account would then be in the red. Well, the Q4 accountings won't come in until, let's say, February or March, and sometimes you'll see record companies apply the January 1st advance against the royalties that should have been paid at the end of Q4. You want to make sure that there's at least clear language that says that the practice isn't allowed, or that there's no way to read the contract that says you can apply advances to monies that have not yet been paid yet. So a little thing to pay attention to with accounting. The other thing with respect to accounting is who is the one that's actually receiving the accounting royalties statements.
You kind of dried up there.
Are they the ones receiving the accounting? And at what soon as they receive the accountings, your statute is running. And if you don't wisen up until 2 or 3 years later down the line that the middleman is the one screwing you over, you can't do anything about those, those statements that have already been rendered.
Okay, let's talk about fiduciary duties. Plaintiff lawyers are always looking for consequential damages and fiduciary duties. Is there a fiduciary duty to pay royalties? Arguably, I think a good case can be made, yes. However, the courts have gone the other way. And I give you the City of Hope case from 2008, and I give you the New York site as well, and it says there's no fiduciary duty overall. So sometimes lawyers have been clever enough to find a fiduciary duty. That happened in the Don Johnson case some years ago on Nash Bridges when they gave him a part of the copyright. And he said, you owed me a fiduciary duty to pay me fairly. He said, no, that was just window dressing. Well, the court went the other way and the jury, and he did just fine. But other case, Roger Rabbit was another case where McDonald's paid a boatload of money to the producer, and the writer said, I should get a piece of that. And he lost. They said, no fiduciary duty there overall. So if you can find a way there should be a fiduciary, if you can find a way, go ahead and get it. But every agreement virtually I've ever seen says there's no fiduciary duty. But I would say this, I don't care. If you're in a partnership with somebody overall, you owe fiduciary duties. That's full disclosure, and to put their interests ahead of your own particular interests overall. But that's a battle that's been going on a long time and will go on for time immemorial.
I think to piggyback off of the fiduciary duty point, I think a lot of us are familiar with the fiduciary duties that say a lawyer or an agent owes to talent. And there's always this question of does the talent manager owe a fiduciary duty to the talent? And generally the law is no, except in certain situations where the manager is controlling the money of the talent. And so you've got to pay attention to situations like that. Is the manager doing something that might be screwing over the talent, like controlling the money, negotiating business, negotiating when the artist actually receives the money? Has the manager then invoked a fiduciary duty to the talent where there otherwise would not have been?
What you say is that you don't think there's a fiduciary duty that managers have, and I beg to differ. I think they do, absolutely, under traditional agency principles. But now, thinking out of the box for the first time on that subject, I've yet to see a manager agreement, and I've been looking at them for over 40 years, that said there's no fiduciary duty between us. But I don't see why you couldn't put that in anyway. I mean, they advise and counsel. They can book gigs, some gigs on behalf of the artist, and certainly in conjunction with an agent. And they're the artist face out there whose job is to advise and advise them on the best way of promoting their careers. All right, well, let's talk to the subject of injunctive relief. Virtually every entertainment contract says you cannot, even if I breach this contract, don't pay you can't stop the release of my film. That's a very typical clause overall. Query whether that would work in the face of an intentional tort, such as fraud or something like that. I don't know, but it's basically a non-negotiable term, and you're going to see it in every agreement happening. I put in the handout, I actually quoted section Civil Code 3423, which says you cannot get an injunction against somebody in a personal services contract unless you've guaranteed them a minimum amount of money, which is $9,000 in the first year, 12,000 in the second, 15,000 in the third, and on. And that, you know, I don't know how many contracts there are these days that provide for those kinds of guarantees, but this has been a law that's been around for a long time. So you need to be aware of it if it's something that's really important. It used to be used against recording artists all the time. What you also need to think about, though, and maybe you don't necessarily need it, is that, and I've seen this happen in my practice, is that artist walks away from company A, signs with company B, just takes one letter to company B saying, I'm going to sue you for interference with contractual relations. So I'd be mighty careful if you put out any product by this particular talent.
To kind of piggyback off of that injunctive relief provision. So there's certainly language in entertainment contracts, especially when there's copyrights involved, saying that, you know, as you're further up the line of the chain of title, that you're waiving the right to enjoin the copyright. There's also language that you'll see sometimes when there's a talent providing services that says that the buyer of the talent will require the talent to recognize and acknowledge that their services are unique, and that the buyer would be entitled to injunctive relief. I don't know how enforceable that is in court, especially in light of the language that Neville had brought up about the minimum payments. But as a drafting note, oftentimes what we'll do is we'll say that the buyer has the right to seek injunctive relief, only because in many cases the buyer won't agree to waive a provision that allows for them to injunctive relief. And so the middle ground there is, okay, you'll have a right to seek injunctive relief, but we won't automatically give it to you.
All right, we're going to go into what I call general rules. General rule number 1, get to the top of the financial waterfall as soon as possible. The more middlemen there are, the more opportunity there is for you or your client to be cheated in some way overall. And it's tough. It's tough to do when you so if you sign to a production company, which say for a motion picture, or invest in one, which then makes a deal with one of the majors, you have no privity to go after the major overall. So you should be getting copies, at least of the financial statements, when and as they are delivered to the production company or the other intermediate person. You can also agree to have a joint accountant. I mean, commonly in personal manager's agreement says we will mutually designate a third party to be the business manager or accountant for us. Well, that would work for me if I was a manager. Then I know I don't have to rely on a musician who might get mad at me and not want to pay me. All right, set up a tickler system for your clients. We had a case where, you'll love this, where our client was a major EP executive producer for a company that had a hit shows, and then the company kind of dissolved, the head guy died, and our client didn't get paid. And we said, where's the money? And they said, we forgot. That's my favorite excuse, dog ate my homework. But what we'd also discovered was that we were past the limitations for the business manager, who should have been involved and acknowledged and understood that their monthly semi-annual payments were coming through and due. And so we went after the business manager for not having adequate safeguards. So we get, in my firm, I know we get accountings on a number of things for work that we've done overall, and I know when that money is due. And if it doesn't come in, I call, or my client calls, and we check into it. But that just means you have to have a tickler system, and in today's modern age, there's no difficulty having that. Loan out corporations. Boy, were they over the last 30 years used a lot, especially in motion pictures for actors, writers, directors, producers, oftentimes utilized for tax purposes. You can get a better depreciation and tax benefits overall. Well, there's a problem. There's a problem with that, which is that if it involves a copyright, you may not be able to terminate the copyright. When you signed over your to your loan out corporation, the copyright in the script that you wrote or the song, the Copyright Act only recognizes a human being can get the reversionary right. And that's how it backfired for John Wade against UMG Recordings, because they said, well, you had a work for hire, et cetera, and your corporation on the copyright, you don't have the right to get it back overall. So be very, very careful about engaging in loan out corporations where there's a potential for reversionary copyrights somewhere down the line.
Which, as a drafting note on that point, I think what we're seeing a lot now is that when there's a particular talent who's both a recording artist and a songwriter, you'll see on the recording contract that the artist will be signing the recording contract under the loan out, whereas when the talent is entering into deals with a music publisher, either for a publishing situation or administration, where the songwriter is contracting with the publisher in their personal capacity and just directing monies to be paid to the loan out rather than having the contract be with the loan out directly.
Related to this is Bozio versus EMI Group, 2016. I give you the site to a Daily Journal article I wrote about this. That was Nobody Walks in LA. What's the name of that group? Anyway, Terry Bozio, she owed taxes, and the corporation had lapsed. That's another reason, or motivation against not having a corporation or an LLC, is you got to keep it up every year with $1,000 in minimum taxes. And so Bozio owed money and was able to get the federal court to say, you know what, you still have standing, notwithstanding you're a suspended corporation, because it looks like there's money there at the end of the line. But I tried that gambit in the last year or two, and the state tax authority said, we don't really need to hear from you, Mr. Johnson. Thank you.
But missing persons, we've got a number of people
just pay the back taxes if you would. Okay, another thing I talk about are foreign sales agents for independent films. As I've told you, I've had a number of situations with indie films, and I'm very unhappy with the general state of affairs overall. They all just live it up and charge expensive marketing fees, etc. And I'm hard pressed to think of any indie films that ever make a profit overall. So what you're doing particularly when you're making these deals with these foreign sales agents or indie distributors is to say you're limited as to what you can charge. I want to see a copy of all of your deals. I have the right to terminate. I have the right to audit at will, etc. In other words, you got to be harsh. They're not putting up any money. If you think about it, overall, you have a $5 million film. They're not putting up the money. What they can do sometimes is they can sell it off. And I'll tell you another trick that we've seen. They'll get advances from foreign distributors, and then they set up a sub-distribution company in these foreign countries and suck out all the earnings that are coming out from those people overall. But so number one rule is marketing expenses, limit those as much as possible. Make sure you're, as I said before, make sure you're in on the investor corporation that is collecting all the money, the collection agent, etc., and monitor it. And I know there are some good distributors out there overall, but it's the Wild West. And I have a client who's a big actor, and he was saying, how come there's never any profits? And the answer is because there's never going to be any profits. The advances that come in to go to the producer, and they never make enough to pay anybody else. But if the client, as I said before, is making many, many millions, there aren't too many crocodile tears. Copyright notes. Here's 4 things to be aware of that are important. You got to register a copyright within 3 months of publication before the defendant first infringes upon the work to get the certain benefits, mostly attorney's fees, or if you want to go for what are called statutory fees overall. So what does it pay? It pays always to register your copyright as soon as possible. If you've registered within 5 years of publication, there's a prima facie presumption of validity regarding the information included in the registration. This is super important, and you should all be aware of it. Recent case from the Supreme Court, you can't file a copyright claim unless you have a certificate of registration from the Copyright Office. And ordinarily it takes, as I understand, 2-3 months to get a copyright certificate back. If you've got to go after it, you can pay, as more recently, we paid, I think, $750. We can get it within a few days overall. Finally, we had a decision this year that made a lot of people happy, which was that the statute of limitations for breach of copyright, for copyright infringement, runs from the date of a reasonable discovery. That's the Warner Chappell Music versus Neely case. So those are many of the topics that I wanted to talk about. I know John has more.
So just to piggyback off the copyright note, there is one concept that floats around in the music industry context, and that's the idea of copyrights in musical compositions, right? By default, if you're a co-author of a composition, you all share equally in 100% of the copyright of the song. However, in the music industry practice, what we see is that writers, through contractual vehicles, will have language that says, well, each writer gets to administer their respective share of the composition exclusively. And it's a provision that is very necessary in order for the publishing industry to survive in the manner that it does. But the question comes up is, what happens if there isn't an actual split sheet signed or any agreement that contains this language that the writer controls and administers their work exclusively, and one writer decides to threaten a takedown notice? I don't know that case has actually gone to court. At least I'm not personally aware of it, but you see threats of takedowns all the time. Oftentimes with producers that haven't been paid, who say, you know what, I'm going to enjoin the use of my sound recording and the use of my composition because no, you haven't paid me. I haven't given you the right to use my song that I co-wrote. Well, technically, I don't think the artist needs that right. As a co-writer, anyone has the right to exploit the composition as long as they're properly accounting the respective shares. No, we're out of time, but I'm going to rattle off a few other points. Won't go into too much detail, but there are certain points that will come up. Sometimes you'll see in entertainment contracts, and I'm not talking about settlement agreements. I'm talking about regular service agreements, where it has a waiver of rights under California Civ Code 1542. For those of you who aren't familiar, that's a waiver of your right to release claims that are known or unknown. I don't know why that exists in a transactional context, other than the talent buyer might be saying, you know what, if I've hired you in the past, you can't sue me for it anymore. But if you see that in a transactional setting, that's very quickly going to be one of the first things you strike out. Other things you need to be mindful of is certain contracts will have language that says you're going to consent to service of process by mail, and it'll be effective service in the jurisdiction of the choice of law that's chosen in the agreement. Now, of course, the practical issue there is, well, what happens if you've changed addresses, or you've changed attorneys, or you've changed representation, and they just mail it? Now you're being sued and you're at risk of getting defaulted because you didn't even know a lawsuit was filed against you in the first place. There are other provisions with regard to influencer agreements. There's this concept of sequential liability. Oftentimes brands, major brands will go through an agent to employ talent to do these influencer agreements, where the contractual privity is between the talent and the hiring agent. And you'll see a provision in there that calls for sequential liability, in that the brand will not be liable for paying the talents, or rather the agent will not be liable for paying the talent's fees unless and until the agent has actually received the money from the brand. Now that becomes an issue, obviously, because from a contractual standpoint, the talent doesn't have privity with the brand itself. Now there might, of course, there's claims of whether there's, unjust enrichment from the brand, engaging in the services, but from a contract standpoint, the talent can only go after the agent, and the agent's not on the hook until the agent has actually received the money. Well, if the agent hasn't received the money, then what relief does the talent actually have there? With respect to independent contractor language, it shows up all the time in entertainment contracts, regardless of what the relationship is. Just be mindful that when you're in California, there's California employment laws that really bust up what you want to call yourself. Certain states will allow you to be an independent contractor as long as you call yourself an independent contractor. But California is a lot more stringent. You've got to satisfy the ABC test in order to prove that someone is an actual independent contractor. In the music context, you'll often be faced with insurance obligations in contracts involving live performance. Let's say that you're a talent and you're doing a small show, or you're a DJ, you're performing at a festival, and there's a requirement that you, as the talent, are providing general liability insurance and naming the talent buyer as additional insured. Well, if you're smaller talent, you're making a small fee, and then you're required to pay insurance just to get that fee. That's already eating into your small earnings to begin with. The other thing with respect to those contracts for festivals in particular is when you're a smaller talent, local talent. Let's say you're a DJ in LA, and you want to perform at Coachella, but there's a radius clause that says you can't perform any shows for from the time period 6 months leading up to the performance, but the performance is still 4 months away, right? We're in January, and the show's in April. Are you then expected to not work in LA up until the date of your performance at Coachella? Particularly when you're not even a headline act. It's something to be mindful of that shows up in those types of agreements, particularly with small artists. Right to use AI. This has been a developing fight, and I know that this area of law is really unknown quite yet. But there's always this fight where if you're the talent, and particularly in situations where the talent's works are considered work for hire, does the buyer have the right to use the resultant proceeds of your services for AI? You as a talent rep are always going to fight that you can't use it for AI without my permission, or you'll even take a harder stance and say, no, you don't get to use it at all. And we kind of saw these with NFTs earlier, right? Whether or not you can use the resultant proceeds as part of NFTs, whereas the buyer is going to try and push for the right to include it in AI for whatever purposes they need, because I bought the copyright, so it's mine to do whatever I want. And I think the middle ground, or at least the approach right now, is that if a company doesn't want to address the AI issue, they just leave it out of the copyright, out of the contract. And even if you try to insert language that says, you know what, I don't want you to use my works in AI context, and I'm going to put it in there, oftentimes the response will be, you know what, we're not going to address it right now. So I'm not agreeing to your comment. I'm not saying that we'll do it. I'm not saying that we won't, but we're just not going to address it. And so it kind of potentially leaves this gray area in the contract. Again, in the music contracts context, you're talking about language that when you're delivering a work, it's going to be technically and commercially satisfactory. Technically satisfactory, I think we kind of understand that, you know what, if you turn in something and we're not even able to distribute it and use it, then clearly it makes sense why we can't count it as delivered. But when you're talking about a commercially acceptable, commercially satisfactory standpoint, now you're talking about, well, does the label have the right to decide whether or not your music's even good enough? Say you turn in a full album and the label says internally, you know what, this album sucks. And now you've opened the door for them to say, you know what, it's not commercially satisfactory. We're not going to deem this record as delivered. There's certain language you put in there that says, you know what, if it's consistent with, with works that the artist has produced in the past, then it'll be deemed commercially satisfactory. But there's often a fight about what commercially satisfactory even constitutes. And the last point I'm going to bring up is kind of related to that. This idea of what happens when an album is delivered, right? Or you're trying to terminate a recording agreement. When, as a talent, you deliver works and either the label doesn't want to put it out or decides, you know what, halfway through the project, we're kind of done with this artist. They want to drop. Now, in the normal setting, anything that was created by the artist during the term of that agreement before the artist was dropped, all those works belong to the record label. But what happens if the artist is really just upset at the label and wants to get out of the contract and the label says no, right? We're just going to hold you hostage forever because you don't want to comply with us. We don't want to comply with you. And so as punishment, we're just not going to release you. Well, there's certain vehicles that you could put in there that say, you know what, you have to release an album within a certain amount of time frame, or you might have pay or play language that says, you know what, if you don't want to put my stuff out within a certain amount of time, then pay me, buy me out. And you can even try to put in language that says, you know what, if you're not going to work my album, then at least give me those rights back. And it becomes a negotiation of, well, okay, fine, we'll give it back to you, but who paid for those recordings? If we're the ones that paid for it, then give us an override royalty on a subsequent contract. Oh, and by the way, we paid you in advance. Since you want to terminate, you pay us back the advance. That becomes a fight that you then have to deal with because you know what, you probably don't have that money anymore. And in order to get out, you're being asked to pay it back. But you can mitigate that by adding pay or play language also, saying, you know what, fine. At least if the pay or play language is sufficient to cover the advance that's already been paid out, then I don't have to pay anything back because that's my out clause. And I think that's as much as I'm gonna cover today.
Give you a couple of. We have one thing I want to mention, and I think there's one or two questions. Stems. I am in litigation right now over stems, and I'm settling another case involving the same thing. Stems are the individual tracks that the record producer uses, and now what's happening is the talent or the record company or the entity placing music into film and TV wants all the ability to remix it and do it themselves. And in the case I represent producers, and they're saying, I'm not giving you my toolbox. I'll give you some of the stuff, but not all of it. And it's unsettled overall. So that's something to be aware of at percolating. It says, do I have an opinion, do we have an opinion of Jams Entertainment and Sports Group? I think everybody at Jams is pretty talented. No, I have nothing negative to say about them, but again, there is the concern that they may be overly biased when it comes to situations involving major studios. Somebody mentions the Limp Bizkit versus UMG lawsuit where they didn't get royalties, and the band is saying they should have gotten 3 million. Agreed. One person said it was missing persons that I referenced. That's absolutely right. Another person says, will there be any viable future musical copyright infringement cases in wake of the Sharon decision? Yeah, sure. There always are going to be some, and they can go both ways, and you never really know. But you know, he was found or settled out on other cases overall, and I would say in my experience over the years, there's theft of idea, theft of music is commonplace. That's people who are executives don't advance and they get fired if they don't come up with good shows or good, songs, etc.
No, there's even that case that you and I are sharing where
Yeah,
there's a writer that's trying to claim copyright infringement of an entire genre of music.
that's right.
So yeah, there's going to be cases out there.
John, on the service of process by mail point, I would add it's advisable to include a clause requiring courtesy copies sent by email, but should explicitly state that they do not constitute legal service. That's right. For AI point, a possible resolution is if it will be used in AI, the parties have the right to revisit and negotiate the AI use. I say absolutely right. What's the best way for a law student to reach out with follow-up questions after the seminar? I don't know, send them to John. Or me. All right, ladies and gentlemen, that was, I'm very gratified we could do that. I hope you all appreciated it, and we look forward to seeing you down the line. Thanks, John. Thanks, BHBA.
So,
All the best.
thanks all.
You may be eligible for CLE credit in your state. Visit bhba.org/podcasts for more information.